Salient features Maternity Benefit Act 1961, Factories Act 1948. Women are not allowed to work between 7 p.m. and 6 a.m. The Act provides for the maternity leave. The factories are required to provide separate latrine and urinal for female workers. Factories with more than 30 women workers must provide childcare facilities for the children below the age of 6 years. The Act prohibits the employment of children below the age of 14 years in any factory. Adolescents can only be employed if they have a certificate of fitness. Adolescents are restricted to work a maximum of 4.5 hours a day, and they are not allowed to work overtime. Factories employing adolescent workers must maintain a register with details of these workers. Maternity Benefit Act 1961. The act applies to the women employed in factories, mine, plantation, government establishment and shop and other establishment as defined by the law. Women are entitled to maternity leave of 26 weeks for the first two children, and for the third children and subsequent children the leave is 12 weeks. During the period of maternity leave, women are entitled to receive maternity benefit, which is the average daily wage for the period of her actual absence. The Act allows for the option to work from home if the nature of the work permits it, upon mutual agreement between the employer and the woman employee after the end of her maternity leave. Again, this act also provides the childcare facilities to the women and the children. Establishment with 50 or more employees are required to provide childcare facilities. Women are entitled to the medical bonus if the employer does not provide prenatal confinement and postnatal care free of charge. It is unlawful for an employer to discharge or dismiss a woman employed during her maternity leave period, except for gross misconduct. Municipal Corporation of Delhi versus female worker, also popularly known as muster roll case. The Municipal Corporation of Delhi employed female workers on a muster roll basis, that means on the contractual basis. These female workers demanded maternity leave, which was granted only to regular employees. The MCD denied them maternity leave, arguing that their service were not regularized. The Supreme Court upheld the tribunal's decision and affirming that female workers on muster rolls are entitled to maternity benefit if they have been in continuous service for more than 3 years, or at least three years. Manisha Priyadarshini versus Aurobindo College Evening 2020. Dr. Priyadarshini had been serving as an ad hoc assistant professor since 2013 with a specific renewal and brief break in service. In March 2019, she applied for maternity leave. The college denied her request, stating that the maternity leave benefits were not available to contractual employees. Subsequently, her services were terminated and junior ad hoc lecturers were appointed in her place. The division bench of the Delhi High Court upheld the single judge decision, stating that the ad hoc employees were not entitled to maternity leave under the existing rules. The Supreme Court of India criticized the college's stance, emphasizing that maternity is a natural aspect of women's life and should not impact her professional opportunities. The Supreme Court ruled in favor of Dr. Priyadarshini, stating that denying maternity benefit to ad hoc or contractual employee is unjust. The court imposed a fine of 50,000 rupees on the college for its conduct. Further, Dr. Priyadarshini was held to be fall within the ambit of Maternity Benefit Act 1961. As per Supreme Court judgment, the court affirmed that the status of an ad hoc employee did not disqualify her from availing maternity benefits.